welcome to the Federal Trade Commission. Today I am pleased to announce that Google and YouTube have agreed to pay $170 million and to implement strong conduct relief in settlement of an action brought by the FTC and the New York State Attorney General's Office for alleged violations of the Children's Online Privacy Protection Act, commonly known as COPPA. Let me start by explaining why we allege that Google and YouTube violated our rule implementing COPPA. COPPA requires that certain websites and apps get parents' consent before collecting personal information from children. The definition of personal information includes cookies used in behavioral advertising. The COPPA rule applies differently to third parties serving behavioral ads versus creators of child-directed content. While the content creators are strictly liable for COPPA compliance, third parties are subject to COPPA's requirements only where they have actual knowledge that the website or service that they're serving the ads to is child-directed. To put it in context for today's case, YouTube as a general audience platform is not directly strictly liable under COPPA for the content of the videos uploaded by others to its platform unless it has actual knowledge that the content is child-directed. Our complaint alleges numerous instances in which YouTube and Google had actual knowledge of the child-directed nature of channels and videos on the YouTube platform. This is the basis for the FTC to find that Google and YouTube violated COPPA. Our order accomplishes three important purposes. First, it imposes a substantial monetary judgment of $170 million, with $136 million going to the Federal Trade Commission as a civil penalty and $34 million going to the state of New York. The $170 million judgment is 30 times larger than the largest COPPA civil penalty the FTC has ever previously obtained. It is 3 times larger than any privacy penalty assessed against Google anywhere else in the world. And it is 10 times larger than the civil penalties we have obtained in all of our 31 prior COPPA cases combined. A penalty of this magnitude sends a strong signal about the importance of children's privacy. Second, the order requires the companies to refrain from using or benefiting from the data that they previously collected from child-direct videos or channels. Third, the order imposes additional obligations on Google and YouTube that go beyond the requirements of COPPA. The order requires YouTube and Google to notify channel owners about their potential COPPA obligations. It also requires YouTube to develop a system or a mechanism through which channel owners must identify their child-directed content on the YouTube platform so that such content can be treated in a COPPA-compliant manner. This is particularly significant because COPPA does not require platforms such as YouTube to determine whether the videos posted by others are directed to kids or not. Going forward, YouTube and Google will automatically have knowledge of and COPPA liability for all child-directed content designated through this mechanism. In this way, the order prevents YouTube and Google from turning a blind eye to the existence of kids' content on the YouTube platform. Finally, YouTube must provide annual training about compliance with COPPA for employees that deal with the channel owners. None of this is required by law. No other company in America is subject to these types of requirements, and they will impose significant costs on YouTube. This case sends strong messages to third parties like YouTube, channel owners, and the business community as a whole. For YouTube and other third parties like it that serve ads, they can't market their ability to get child viewers on the one hand and disavow knowledge that children are using their service on the other. They can't rate videos as kid-directed for one purpose and then say they have no COPPA liability when they collect information from kids watching those videos. For those who create child-directed content to upload on YouTube, the message from today's case is that the FTC considers these videos and channels to be websites or online services directed to children under the rule and thus strictly liable for compliance with COPPA. Once our order has been effected for a period of time, the Commission will conduct a sweep of the YouTube platform to determine whether child-directed content is being properly designated as such in order to ensure that the channels themselves are complying with COPPA. Finally, to the business community at large, let me be clear. The FTC takes its obligation to enforce COPPA seriously. If companies violate COPPA, the FTC will take aggressive action, require corrective measures, and use its authority to seek substantial civil penalties. Let me close by thanking our partners at the New York State Attorney General's Office, and I would like to thank in particular the FTC staff attorneys, Kristen Cohen, Tiffany George, and Peter McGee, for their tireless work on this case. Thank you, and I'd like to turn the podium now over to Andrew Smith, our Bureau Director. Thank you.
Thank you. So the floor is open for questions. I want to reiterate, while you're collecting yourselves for questions, that some of the points that the chairman made. First, that this is the first time that we are holding a platform liable under COPPA for content on the platform. Second, this is an historic penalty. The chairman outlined that it's 30 times greater than our next highest COPPA penalty, more than 10 times all of the COPPA penalties cumulatively imposed to date, more than 3 times larger than the largest privacy penalty ever imposed on Google in any country, any regulator. I also wanted to note, it's a sort of a topic near and dear to my heart. It happens that $170 million is roughly the budget of the Bureau of Consumer Protection for 1 year. The agency budget is $300 million. $170 million of that is dedicated to us. So with this action, we are actually reimbursing the Treasury and the taxpayers for our operating expenses for this year. So no need for all of you to thank me now, but you're welcome. And maybe most importantly, that this action is changing YouTube's business model. That YouTube cannot bury its head in the sand. YouTube cannot pretend that it's not aware of the content on its platform and hope to escape liability for COPPA. YouTube is going to be explicitly held liable for COPPA where it has actual knowledge of the content. YouTube is going to be required to seek out that actual knowledge through requiring content creators and channel owners to specifically designate whether they are directed to children. And as the chairman noted, not only can we sue Google and YouTube for compliance with COPPA, but also individual channel owners and content creators. And once this order has been fully implemented, we intend to conduct a sweep of the YouTube platform, determine whether there remains child-directed content on the platform with respect to which personally identifiable information continues to be. So, questions? Yes, Margaret. Oh, microphone.
Oh, thank you. Margaret McGill, Politico. Can you say what prompted this investigation?
Our investigation was prompted by complaints from consumer groups. No, Manisha? Oh, so we had started the investigation prior to that, and we also received complaints. And I want to note that we appreciate our partnership with consumer advocates and privacy groups, and that we rely on the good work that they do to help us to enforce the law. Yes, question.
Hi, Brian Tracy with the Wall Street Journal. This is another 3-2 vote following the 3-2 vote on Facebook, what, in your view, is the impact of having a partisan divide on a couple of these large settlements going forward?
So I hope that business does not doubt our resolve, that this is an historic penalty. It is staggeringly large in the privacy world and in the COPPA world. I am a little saddened, I have to say, by the partisan divide. This is a really strong thing. I think that it passes muster under anybody's standards. I also, however, appreciate the concerns of our two Democratic commissioners and the concerns voiced in that in their dissents. I would note that both their dissents indicate that this is a thorough investigation conducted by staff, that the law violations are clear, and that the relief that we get is strong. It's just that they wish there was more of it. Yes, there's a question right in front here.
Thank you, Dave. You've referred multiple times to the sweep that the FTC will conduct. It's an important part of the enforcement of this order. Yet there are 23 million channels that upload a combined 500 hours of video every minute. So, given that amount of content, what kind of meaningful sweep can you conduct?
Well, I think that we have a variety of tools at our disposal to cull through those 23 million channels and in an expeditious way. I mean, this is the way that we generally enforce COPPA, is by actually reviewing content to determine if it's related to children. We have a variety of factors in our rule that we consider when determining whether or not content is directed to children. And so that's the way we do business. It has been successful so far. I think that I have no doubt that it will be similarly successful with respect to YouTube, despite the large quantity of information on the platform.
Raquel Martin with Nexstar Media Group. Just concerned about the data that was collected, because obviously they are being fined for collecting some sort of data. What happens to that? Is it anything retroactively going to happen to destroy or remove that content from their possession?
Right. So under our order, YouTube is prohibited from using this already collected data for any purpose, even purposes that would be permitted under the COPPA.
Would make content creators to misidentify programming to ensure that they continue to receive real advertising. Can you respond to that criticism, and how might the FTC combat that?
There is apparently, we've learned this investigation and in the now information in the public domain, that there are benefits to gathering information and targeting advertising, and so it is possible that content will. So one response to that is that second response to that is that there will be consequences for content being kicked off the YouTube platform. So if content creator sincere or forthcoming with YouTube and designated as being directed to children, there will be consequences for them. We also think that YouTube has strong incentives to police its platform, both to avoid future enforcement actions by the FTC, but also because it's offering this platform to content creators. And if the FTC is bringing independent piecemeal actions against content creators for violating COPPA, that may discourage content creators from posting content on YouTube. So the analogy that I think of, if perfect, is the expression about shooting fish in a barrel. And YouTube is the barrel, and the content creators are the fish. And so it's a place where this content is centralized, and essentially it's easy for us to find. Yeah, up in front here, Mitch.
Okay, so the chairman talked about Oh, I'm Diane Bars with Reuters. So the chairman was talking about how YouTube was not strictly directly liable. Did I get that right? But the content creators are under COPPA. And you're talking about a sweep going forward. So does that mean that COPPA violations committed by maybe YouTube channels previous to today are not being looked at? Or am I misunderstanding something?
Yeah, well, we're not saying that. I mean, there is no release in this order for other channel owners or content creators. Whether we are bringing actions against individual channel owners or content creators, I couldn't comment on here. I can't comment on any investigations that either that we have them open or that we don't have them open. So don't take that away from what the chairman said. I would say that with respect to strict liability, it's important to keep in mind what the COPPA rule does and what the COPPA rule doesn't do. So what COPPA does is it prohibits the collection of personally identifiable information from children under the age of 12 and under without verifiable parental consent. On the internet, though, you don't know who your users are. So what the COPPA rule more specifically does is where the content is directed to children, we are presuming that the users are 12 and under. So if you are the purveyor of child-directed content, we are presuming that your users are 12 and under and you cannot collect personally identifiable information from them without verifiable parental consent. If, however, you are a general audience platform, YouTube, you don't know what the content necessarily on your platform is. So we, under our rule and under the statute, you are only held liable if you have actual knowledge that the content is child-directed. So that's what we mean when we talk about strict liability for content creators, but a knowledge requirement for a general audience platform like YouTube.
Thank you for taking my second question. Another criticism of the settlement today has been an alleged double standard by the FTC that it holds small COPPA violators individually liable for the COPPA violations, whereas YouTube, Google, big company, Silicon Valley, no individual executives have been held accountable in this order.
So I differ with that characterization of our COPPA enforcement to date. I do not believe that we treat small companies and big companies differently. With respect to an individual liability standard for a civil penalty, you have to show that an individual has actual knowledge of the violative conduct. That, as a practical matter, is much easier to do in a company with 2 employees than in a company with 200,000 employees. In addition, we typically seek individual liability where we need to fully protect consumers, whether it's to get money or to get an injunction that will actually be enforceable. And so in small companies, what you frequently find is that our concern is that the owner of the company, the principal of the company, will simply shut down and move across the street and do it again. So it's very important to get it under order. Also, you don't typically have those circumstances company, but I would say that with respect to the assessment of civil penalties, we tried and I think succeeded in being even-handed, and that's why this upping number for Google. So what we typically do is we look at the revenue that was earned from the violative conduct, and we apply a multiplier to that revenue based on the circumstances of the individual case in front of us. That's what we did in Musical.ly. That's what we've done in all of our other COPPA cases as well, at least the ones on my watch. So we have. So I think that we have something of a rubric for assessing civil penalties and individual liability under COPPA, and I believe that we have applied that rubric equally to small and to large companies.
Hey, Ben Brody from Bloomberg. You talked a lot about the knowledge requirement, and in the complaint, about YouTube basically touting its young users in its advertising materials. Given the steps that are going to be taken today, what what could really prove that YouTube had actual knowledge of data being collected on child-directed content in the future if this sweep maybe suggested that YouTube is still collecting this data? How could they really be held liable?
So the injunction is going to help because there will be a requirement that they actively inquire about whether or not content is child-directed of the content creators. Other than that, we have the same enforcement and investigative tools that we have always had under COPPA and that we used to prove up this case. So we have knowledge, we have evidence of actual knowledge of YouTube and Google that this was content that was directed to children. We back that up with various states which are highlighted in the complaint about, YouTube is the new site on television, and YouTube is the most popular site for children ages 2 to 12, that kind of stuff. So we have those tools at our disposal as well. But you're right that actual knowledge can be a tricky thing to show, and it can be very fact intensive. So in this case, if we were to have gone to litigation with this case, we would have had to prove actual knowledge of every single channel, and in order to obtain penalties for law violations with respect to that individual channel. Yet another reason why this is such a great number that the staff has been able to put up with this civil penalty.